very well done. So I can't see anyone's faces in here, but if you competed in that, excellent job. And the John Black Moot Court competition, which is the one that this learning lunch is for, is specifically to give 1Ls moot court experience, and to kind of, especially if you're interested in trying out for the moot court team. Ding, 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 hint, 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 hint. This is the competition to do. And then we also, as Emma said, we have our one more competition after this one, and that is the Lawrence Thompson Negotiation and Contract Drafting Competition, which is open to all students. But FYI, 1Ls won last year. They won both the negotiation part and the contract drafting part. So even though that one's not specifically geared towards 1Ls, you are welcome to compete, and 1Ls have been very competitive in the past. So yeah, that's a rundown. And then we have 3 more in the fall that are open to all students.
Cool. Thank you so much, Chelsea. So a little overview of the John Black Moot Court competition. So of course, this is an intramural competition. Um, Only 1Ls are eligible, and I think that that's probably the biggest thing that you need to remember. Like, you're not going to be competing with 3Ls who have, done 5 different competitions. You're competing with your peers. It's just a really good way to kind of like gauge where your oral advocacy skills are right now, and just like be able to think about how, be able to think about if you want to do litigation, for example, be able to think about your future legal career, and the oral skills you'll need, to advocate for your client. um, so the competition, I think I mentioned this in my email, but I'm not sure. I know I've sent you guys a ton of emails. The competition is going to be from March 5th to the 7th. So we don't know the exact schedule yet because it's just going to depend on how many of you guys sign up. But preliminary rounds will start on March 5th, so it's a Friday, and then they'll finish up on the 6th, and then on that same day, the 6th, we will do the quarterfinals. So that's going to be only the top 8 teams. And we'll do the semifinals, and then the following Sunday, there's only one round, and that's March 7th. And it's going to be the final round. So the registration period is going to be from the 19th, which is today. As soon as this session is over, you're going to be able to register online. And it's going to be from now until the 24th. So we realize, it's kind of a short registration period, but we really want to make sure that we have that cutoff date at the 24th so that we can get you guys the problem. So as soon as registration closes, like about 15 minutes after that, we're going to send you guys the problem. And then you'll be working on it from then until March, until the end of the competition. You must sign up as a team. So I got a few of these questions. I got a few questions about whether, you have to sign up as a team, whether you can do this competition independently. The answer is you do have to sign up as a team. And as we get through this presentation, you'll kind of understand why. The competition is limited to the first 32 teams that sign up. So definitely sign up in the earlier part of the period. And the cost for the competition is $10 if you are an Advocates member. And you can become an Advocates member. I think, Chelsea, what did you say? Was it anytime?
Yes. So especially for you 1Ls who have 2 more years of law school after this, go ahead and join, become an advocates member. You can join anytime up until you register for this competition in order for the discount to apply. So you can go right now to our website, join the advocates, get that sweet discount of $10 for you, and then, however much for your teammate. And then, and then you get to, that's what's the word? It applies, it's a lifetime. There we go. It's lifetime membership. So it'll apply even for the years to come. So it will save you lots of money. So take advantage of that sweet discount. But once you pay for this competition, the $50 as a non-member, then we can't retroactively, apply the discount after. So it's important that you join first if that's what you intend to do.
And I think it's also like, I remember when I was a 1L, so I did John Black, which is why I wanted to be a director this year, because I know how important it is. I know, like, that's how I fell in love with moot court. And I remember kind of like weighing, it's like, okay, well, do I really want to spend all that money, not even knowing if I'm going to like the advocates and not even knowing if I'm going to like moot court? Um, the good thing is that, as we said before, there's multiple advocates competition. So even if for some reason you hate John Black, you hate the moot court kind of structure, there's so many other competitions that you can compete in. And I think on the next slide or in a few slides, I'll kind of get to why it's really important to compete in advocates competitions at all. And so let me go to the next slide. So why should I participate? So of course, as I said before, this competition is going to help you strengthen your oral and written advocacy skills. You're going to learn how to analyze very complex legal issues. I think it actually really makes you a better law student as well, because you're going to be looking at cases, you're going to be writing, you have to, I think, like for me, at least like in law school, it was, I didn't love like reading 100 cases and then like I didn't love cold calls, I don't like the finals. It's all kind of it was kind of miserable for me in 1L. But I think with moot court, it's kind of cool because you are advocating for your client. Yes, it's a fake client, of course, but you're actually getting to apply the law instead of just kind of think about it in a theoretical way. Um, and so, also really important, you get to earn 1 hour of retroactively applicable credit. So I'm a 3L. This semester, I'm only taking 3 classes, but I think I'm taking in total like 14 hours. So I have a ton of competition credits. And so it's really helpful when you're a 3L and you are burnt out and or you're working. It's just like it's a good kind of thing to have in your arsenal. Boost your resume. This is a big one too. I know that we have a variety of people here, so depending on I think it's like even if you want to do big law or if you want to do public interest or really whatever you want to do, everyone knows what moot court is. Every single law school in the country has a moot court team. Um, I think that you know there are different opportunities where it's like okay, like will this this might boost my resume, but I think with moot court it will it is like a very strong thing to have on your resume. So of course, experience moot court. This whole thing is kind of it's about moot court. Um, have an advantage for the moot court team tryouts. So the moot court board has confirmed that they are using this problem for the tryouts. Um, so, say you participate in John Black, you absolutely love it. You realize that you want to do the moot court team. You, of course, have to try out. Everyone has to try out. Um, but once they conduct tryouts, you will know the law very well. You'll know your oral argument very well. You will have already gone through a few rounds with judges. So you have a pretty strong advantage when you try out for the moot court team. The next thing, the winning team gets a cash prize. That's just kind of fun. And then this last point I think is unique to this year because of the pandemic and because of Zoom. I know that a lot of you guys are not really able to connect with your peers in the same way that previous years were. So I think this is a really great opportunity to meet those peers who you may not have met. Um, because as I said before, you do need to sign up with a partner. So if you're sitting here thinking, okay, I don't know anybody, I think this is a really great opportunity to post in Facebook groups. I'm sure you guys have group me's. Even in this chat, you could, if you're scrolling through this list and you say, okay, like I see Chelsea on here, let me just privately chat her and ask her if she wants to be my partner. You could do that too. I think this competition is the first, at least for me, it was the first time in law school where I was like, okay, I'm able to actually work with a partner. I know, a lot of us are like, oh, like teamwork is terrible, but this is law school, so I think it's not like it's not like you're going to have a teammate who doesn't care. Like if they're signing up for this competition, they care. So I think it's going to be really fun to work with somebody and create, a brief, which I'll get to, and create a really strong oral argument. So how do I earn credit? So that retroactive credit we were talking about earlier, you need to submit a brief to me by 11:59. And by the way, I'm going to email out the slides. And I think, we're recording. So submit a brief to me by 11:59 p.m. on March 15th. That gives you all of spring break. And I know you're thinking like, oh my God, don't want to do law school during spring break. Or you're thinking, okay, I need to like outline like crazy over spring break. This brief is very low key. We know that it's your first brief. As long as you demonstrate a good faith effort, you're going to get credit. It needs to be so it'll depend on like whether you both want credit, but of course I very strongly encourage you both to petition for credit. So it'll be 6 to 10 pages. It's one brief, double spaced. It really will not, it's really not that scary. If you feel a little scared, don't feel scared. It's really not that bad. By the time this brief happens and by the time you're writing it, you're going to know your cases super well. You're going to know the facts super well. You will have already done your oral arguments. So it's really okay. Don't feel like if you're sitting there thinking, this brief makes me not want to do the competition, don't think that. It's really not that bad. Let's go to the next slide. Okay, so now we're going to get into what a moot court round looks like. I know that for me, again, I'm speaking about my own personal experiences. I had no idea what moot court was. I had heard of mock trial, but I was pretty confused about what moot court even was. So let me start by saying so moot court is at the appeals level. So mock trial is at the trial court level. You're arguing in front of a jury, a judge, whatever. Moot court, you are arguing in front of a panel of judges. It's usually 3 judges. So you're at some court of appeals. So the way the structure works is the appellant or petitioner goes first, and then the appellee. I'm still not even sure how to say that word. We usually just say respondent. They go second. So the petitioner will go, like partner number 1 will go, and then petitioner, your teammate, will go, and then the other side will go. So you can see it right here on the slides. It's probably easier to see it instead of hear it. And then after both sides have gone, the petitioner is the only party that gives a rebuttal. And it's only one of the like team members. So between you and your partner, you're going to say, hey, I would say, hey, Chelsea, I really feel like you're going to be better at giving a rebuttal because you clash really well, and we'll get into clash in a minute. And I feel like you're really strong at like getting on the other side. So you're going to say, Chelsea's going to go up there and be like, respondent argued this and this is wrong because blah, blah, blah. So you're going to really want like a fiery rebuttal. So in terms of time, each side is going to get 25 minutes. So usually that means like you're going to divide it evenly, or if you're a petitioner, you're probably going to divide it. You're going to set aside 2 minutes of those 25 minutes for rebuttal, and then you're going to divide the remaining time between you and your partner for your main arguments. So it's typically broken up. The argument overall is broken up into 3 parts. You have your introduction and your roadmap. You have your argument. You have conclusion and prayer. And also, y'all, if you have any questions as we're going through this, feel free to unmute yourself and just like interrupt me. And also at the end, I will also take questions. So whatever is easier for you. So the introduction, and by the way, so Rahul is here. He's on the Moot Court board, and he will be giving kind of a mock Moot Court presentation at the very end. So you're going to get to see it. So you're going to introduce yourself, You always start by saying, well, if you're a petitioner, you're going to reserve time for rebuttal. Then you're going to start by saying, may it please the court, my name is Emma Brockway and I represent blah, blah, blah. So that's kind of how the intro works. So of course you need to introduce the issues on appeal. Why are we even here? You need to let the judges know. Theme statement is a really, really big deal in moot court. It's especially a big deal in John Black because it's kind of your first competition and you really need to learn how to craft a good theme statement. But even in future competitions, when you're a 3L competing, it's equally very important. You want to kind of show the court why this case matters, why we're here, what is this case even about? You need to kind of wrap it up in a theme statement. The recitation of facts, it's interesting because I think that every competition I've competed in after John Black does not like a recitation of facts. Judges usually do not like that. In real life, with appellate advocacy, I don't think judges like that. But in this competition, you still want to ask the judges if they want a recitation of the facts. And if they do, which again, usually they don't, but if they do, you're just going to do definitely no more than 2 minutes. I would say 40 seconds. You just want to kind of emphasize the facts that are favorable to your client. And again, as it says at the bottom, be prepared for the judge to just say I already know the case. I already read the packet. I don't need you to go over the facts. So the roadmap, again, I think this will become a little more clear when Rahul goes. And also Professor Simpson is doing an oral argument presentation on Monday, but I will get into that later. But she everything I'm giving you is kind of an overview of moot court and an overview of how an argument works. She is going to be a lot more detailed, and I think her presentation is 2 hours. So yeah, you're going to pick 2 points in support of your issue. You're going to rank them in order of importance. If you can, use the standard of review in your favor. Let's say, I think the next slide talks about that. Yeah, so know and use the standard of review. Know what you want the court to do. I think that a lot of times, I judged John Black last year, so I wasn't the director, but I was a judge. And I think that sometimes competitors get so caught up in the cases and memorizing the different facts and, your outline and everything that you kind of forget why you're there. And so you need to remind the court, hey, we want you to reverse the lower court's opinion, or we want, you to establish a new rule. Whatever you want the court to do, you need to make that known for sure. And then clash, this is what I mentioned briefly earlier. So the easiest way to sum up clash is that it's not like the other side is your best friend. You want the other side, you want to point out why they're wrong. So you need to anticipate their arguments. And again, this might sound like a lot, might sound kind of intimidating, but once you read the fact pattern that I'm going to send you next week, and once you read the cases, and by the way, this is a closed competition, which means I'm going to tell you which cases you need to look at. So you'll be limited. It's not like you're going to be out there researching for 100 hours, oh my God, I don't know if I'm even getting the right cases. You will know what the right cases are because I will give you them. So you need to anticipate the other side's arguments. And I'm so sorry, I forgot to mention this, but in a moot court competition, you always argue both sides. So at some point in the preliminary rounds, you will be respondent, and at some point you will be petitioner. That's a huge, huge thing to remember. So you'll know the other sides because you will have already been preparing to argue that side. Obviously, when you are the respondent, do not argue anything in favor of the petitioner. But I just wanted to let y'all know because I don't think I put that in other slides. You will, and I will edit that slide before I send it out. You will be arguing both sides at some point in the competition. So let me show y'all just like a 1 or 2 minute example of what clash looks like. And again, Rahul's going to go at the end, but this just very short clip shows you what clash is. Can y'all hear this?
Ms. Dinan?
Good evening, Ms. Chief Justice, and may it please the court. My name is Kavya Naini, and I represent Vita Inc. I'd like to start by addressing a point of confusion in this case. Petitioner continually refers to this accommodation as reassignment, but in fact, the accommodation requested here goes a step further. It requires an employer like Vita to violate its merit-based system in order to guarantee a job to an employee with a disability. It is that accommodation that is presumptively unreasonable.
Well, I thought that that's what the ADA was all about, Ms. Naini. I mean, in your brief, you continually say, look, there's been a violation of a neutral rule. But the whole idea of accommodations is that they are violations of neutral rules, that's what the ADA says. Neutrality isn't everything.
That's true, Your Honor. Neutrality isn't everything. However, there is a difference between preferential treatment to get an individual to the level playing field and affirmative action, which is what petitioner's accommodation requests here.
Well, those are just terms. That's just lingo. I don't know what that means.
This can be helped by defining what the level playing field is. Here, a level playing field is an equal opportunity to compete for a vacant position. In the case of a neutral furniture budget rule, an employee with carpal tunnel syndrome might need a special keyboard in order to get himself up to a level playing field. However, what he does not need is a faster computer that will enable him to do his job faster, because that upsets the level playing field. And here, violating a merit-based system undermines employee expectations of fairness, uniformity, and consistency in hiring.
But how can there be any such expectation where Vita has two aspects of its merit-based policy that seem to undermine any objectivity? One is that any supervisor can choose to do an interview, and then on the basis of that interview, any supervisor can decide not to hire a person just because they don't really feel comfortable working with them. That seems to make your objective merit-based policy Swiss cheese.
Your Honor, the interview for the Packer position is best analyzed as a special circumstance.
Okay, so I just want to point out in that argument, did you notice how she started? So she was the respondent. So she was the second group that went. Did you notice, just, you don't have to reply to this, but think about how she started with, I want to address a point on confusion. So she immediately from the start, after saying, may it please the court, my name is blah, blah, blah. She immediately from the start reframed the entire issue, reframed the entire argument. If you are a respondent, your whole job is to clash with the other side. So you want to completely destroy what they just said. Okay, so let's keep going. So you're going to signpost when you're at the beginning of your argument and when you're moving to the next point. So I think that this is really important in terms of organization. You don't want the judge to feel lost in your argument. So you want to say, the issue is blah, blah, or, there's 3 issues, and you're going to say, as to the first issue, blah, blah, blah. It's just really important to keep the judge on the same page as you as you're going through your argument. You need to know your case for sure. You need to know the facts. The competitions, luckily, I think pretty much every moot court competition has relatively interesting facts. So it's not going to be something super boring. I think it will be, especially as I am the director, I know what the problem is. I can tell you it will be interesting. So get ready for that. Use cases to support your argument. Your argument should not just be policy points. It should not just be if it was about, I can't even think, healthcare. It shouldn't just be everyone should have access to healthcare. You need to be able to say in, I don't know, Loving versus Virginia. Obviously, that doesn't relate to healthcare, but in Loving versus Virginia, the court held blah, blah, blah. And that supports my argument because you're not going to say those exact words, but the point is you need the law to back up your argument. You need to bring in the law to back up your argument. So the conclusion, you're going to conclude by briefly saying what you want. And I said this earlier, you want to remind the court what you want. Like, why are we there? What are you even asking for? You need to say, Your Honors, client, whoever it is, has shown here today that we are entitled to injunctive relief because blah, blah, blah. For this reason, appellant respectfully requests that this court reverse the lower court's decision. Something like that. The conclusion does not need to be like 3 minutes long. It should be like, you should wrap it up, but you should still always ask the court what you want. If you're running out of time, and you'll understand this more once you start, practicing those first few times, especially, if you are just like on a roll and you're like, yes, like I'm killing it, I'm doing so good. And the timekeeper, there's going to be a timekeeper, even on Zoom, and they will hold up like 10 minutes, 5 minutes, 3 minutes, 1 minute, 30 seconds. This means 30 seconds. I think in my John Black competition, my 1L year, nobody told me that this means 30 seconds. And I was like, why is somebody doing this right now? But so yeah, this means 30 seconds. I don't know why. If you see that you're running out of time, you're going to say, Your Honor, I see that I'm out of time. May I, and assuming the judge asks you a question, may I briefly respond to your question and conclude? You're going to give the answer to the question and you're going to do your little conclusion. If you're not answering a question, but you are still out of time, so, again, if you're just on a roll, you're going, nobody's asked you a question, but you're like still going, you're going to still say, Your Honor, I see that I'm out of time. May I briefly conclude? And then you're going to conclude. If you are running out of time, don't have a super lengthy conclusion. Like, definitely wrap it up pretty soon. The rebuttal. So I mentioned this earlier, the petitioner is the only one who does the rebuttal. And it is strictly limited to refuting a point that the other side made. So I think sometimes competitors feel tempted to just like rebut what they want. Like, oh, like I know that one argument that I really know is blank. So I'm just gonna do like basically a presentation, like part 2, an oral argument part 2. Don't do that. You really, really don't want to just repeat your arguments. You want to actually address what they said. And again, you'll likely know their arguments, like what they're going to say is probably expected because you will know their argument pretty well. But make sure you really say, like basically like the respondent said this and this is wrong because blah, blah, blah. If the respondent completely misstated the law or the record, like if, the respondent said that the pedestrian was walking across the street at 5 o'clock, but really they were never even on the scene, you definitely want to point that out on rebuttal. Answering the judge's questions, always answer the question, pause before answering. Sometimes like you'll be sitting there, especially in your first competition, you'll be like, oh my God, I know what they're about to say. I know the answer, I'm ready to go. Like you don't even need to finish like your question, I've got this. But still pause before answering. It shows them that you're listening. It shows them that you have like respect for the court. Definitely never interrupt a judge. And this is especially true in real life. And, I've talked to several judges who hate being interrupted. You definitely do not ever want to interrupt a judge. Don't argue with a judge. The judge might ask you a question that is so far out there, has nothing to do with your actual facts. Like they might say, okay, well, what if the pedestrian was like driving a motorcycle and going like 60 miles per hour? And you're like, the pedestrian, like this case is about the pedestrian walking across, like totally irrelevant. You never want to, you never want to argue with a judge or say that was a horrible question. You just want to keep going and say, well, Your Honor, in this case, blah, 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 blah. Or if you really need to clarify, if you need the judge to clarify the question, you can say, if Your Honor is asking blah, 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 then blah, blah, blah. Professionalism. So the first bullet point on this, I would recommend standing. Rahul, you can weigh in on this if you want. Rahul and I have both done these Zoom competitions. We've both also competed in competitions before the pandemic. Of course, when you are in a courtroom, you can't sit. I would strongly recommend standing if you are able to. What do you think, Rahul?
I'll say for at least my competitions, for right now, I think that a lot of the competition committees are pretty understanding about this all. So I would just say, look up your rules. But as far as I can tell, for the ABA competition, one that I'm going to be competing in, we're all going to be sitting, and that's what the rules have said. If you want to stand, you can stand, but it's always about, as Emma stated, professionalism. So you have to just make sure that your appearance looks professional, whether you're standing or sitting.
Thanks for that, Rahul. And then also, you want to wear a suit. So yeah, even if you are sitting, you want to wear a suit as if we were in person, because remember, okay, hopefully by the fall, the pandemic maybe will chill out, and maybe we will have competitions in person. If we do make that move, back to normal, you're going to want to be able to transfer these same skills that you've learned and everything in John Black to competitions in person. And of course, when you're a lawyer, hopefully, God, crossing the fingers, the pandemic will be over. So, in real life, you're going to be standing, you're going to be in a suit. Just keep that same kind of professionalism in this competition. You want to restrict your gestures. I know that John Black, for me, taught me that I sway when I talk. So this competition really kind of helped me realize that. I also say, you kind of want to figure out what your little things are. You don't want to bang the table in front of you. You don't want to be like this. I think it might be different in mock trial, maybe. I'm not sure. But in moot court, you're really just standing there, and you're speaking in a passionate way, but you're not moving your hands all over the place. Show deference to the court. Again, never talk over a judge, never interrupt a judge, never tell a judge that they are wrong. You always want to say Your Honor. Lastly, try not to read too much from your outline. I know that we're on Zoom, so it's actually, I would say, a lot easier to kind of get away with it, but try not to. I think it's going to be better in terms of answering questions, because if you're on, let's say you're on paragraph 3 or, whatever on your outline, and the judge asks you something in paragraph 9. And of course, outlines are not really in paragraph form, but this is just an example. It's going to be really hard if you are so glued to the page and so stuck on your outline. It's going to be hard for you to answer that question about whatever is in paragraph 9, and then go back to where you were in your argument. Also, your camera has to be on the entire round. That kind of goes without saying, but even when you're not going, even if opposing counsel is going, your camera must be on. So for delivery, don't interrupt your opponent with objections. I don't think that anyone would think that you need to do that, but I just want to throw it out there. If your opponent is up there saying things that are just wrong, of course, you need to rebut that when it's your turn, but don't be sitting there oh, that's totally wrong. What is he even saying? Don't laugh or roll your eyes at the other side. This actually, unlike the other point, I think this actually was a problem. I know that in my year, I know somebody who kind of got docked for it when the scoring came up, because I'm not really sure why, but she was kind of laughing at the other side because I guess she just thought like their argument was not very good. Do not do that. Do not laugh or roll your eyes. This is law. Like, you're going to be a lawyer. You need to be professional. When the other side is speaking, I strongly recommend taking notes, especially if you are the petitioner and you need to do the rebuttal at the end. You need to pay attention to how the judges are responding to the other side. And if the judge is really focusing in on a specific point, you need to kind of jot that down and be like, okay, wow, the judge really doesn't like their argument about X, Y, Z. Let me make sure I really, really talk about X, Y, Z. If you finish early, feel free to discuss policy implications. I strongly recommend it. So, if you're like, oh my God, this was a cold panel, meaning like nobody asked me any questions, which is, well, it's not that rare, but hopefully you'll, I'm sure, get asked a few questions. Start talking about the policy implications. Why do we care about this in a policy way? Why does this case matter? If you are running out of time, don't speed up. The other things I kind of already said, so let's move on. So I'm really excited about this. So the final round, which is going to be on Sunday, March 7th, is going to be judged by 2 current real judges and somebody who works at the ADA's office. So again, I'm super excited. These judges are amazing judges, and they're super excited for the competition as well. So you will, if you make it to the final round, you will be judged by real judges, and that will be really cool. Okay, now we're gonna hear from Rahul. Let's see if I can stop sharing. Okay, Rahul, whenever you are ready.
Great. Thank you for the presentation, Emma. Very good. All right, I guess we're going. Madam Chief Justice, and may it please the court. My name is Rahul Rao, and I, along with my co-counsel, Mr. Byer, represent the petition in this case, Ms. Lawler. Mr. Byer will argue that the doctrine of qualified immunity needs to be reconsidered and recalibrated. But I will first argue that Mr. Carter's conduct in this case violated clearly established law, even under this court's jurisprudence. Your Honors, this case shows how qualified immunity sacrifices individual rights for government efficiency. Ms. Lawler did nothing wrong and was a good employee, but was fired because of her husband's speech. The petitioner asked this court to send a message that no person is above the law, not even Mr. Carter. This court should reverse the 13th Circuit Court of Appeals for 2 reasons. Firstly, for the purposes of qualified immunity, the purposes of clearly established law is a broader standard that requires fair notice. And secondly, Mr. Carter had fair notice that his conduct violated clearly established law. Now, going to my first point, Your Honors. This court in Harlow did establish qualified immunity and established the clearly established law standard. It said that for the purposes of a public official, that when a public official who's a reasonable person violates clearly established law, he's subject to qualified immunity protections. Nevertheless, this court in Harlow found that, it narrowed the view of clearly established law, but this has always been under a clear legal principle because it's always been under police officers. This court has found that police officers are subject to split-second decisions that decide in their life or death. In this case, however, Mr. Carter had no decision that he can make. If you look at the record on page 4, Mr. Carter had ample time to decide whether he violated clearly established law.
Counsel, I just want to stop you right there. What's wrong with what Mr. Carter did?
Your Honors, Ms. Lawler did nothing wrong. She was a good employee. She was loyal to the department. She was fired because of her husband's speech. If you look at the record at page 5, Mr. Carter wanted to send a message to every single employee in the department. Mr. Carter was subject to corruption charges, and he was noted for it. Mr. Lawler posted on a blog about this, purely political speech. However, Ms. Lawler did nothing. She said nothing because she wanted to be a good employee. However, Mr. Carter disagreed and wanted to send Ms. Lawler and people like her a message that if you do not remain loyal to Mr. Carter and political officials like him, you'll be subject to termination and a retaliatory firing that's unconstitutional under the First Amendment of this Constitution. That's the reason why the 13th Circuit found that Ms. Lawler did have a First Amendment claim. However, the problem with this case is that the court went to the first prong of qualified immunity, in that it stated that there was a right in question that was violated. However, the court then went to the second prong and stated that there was no clearly established law violated. In that case, the court found that there was no binding Supreme Court case and an appellate court case. Therefore, Ms. Lawler lost and had no opportunity for discovery. But that is not the standard that's been the majority for circuit courts across this country.
Okay, so how many circuit courts have held in your favor? Like, not they haven't seen these exact facts, but I mean, I'm trying to get an idea. Is like, are you telling me, counsel, that there's a circuit split, or how many circuits have created some type of law that would be favorable to you?
Yes, Your Honor. To answer your question very briefly, 5 circuits are in her favor. 3 circuits, including the 13th Circuit, find that only a Supreme Court precedent and a binding appellate court case will establish clearly established law. However, the majority of circuits have found that there's a reason why such a standard shouldn't exist, a narrow standard that the respondent would entail, because it blocks discovery. A plaintiff like Ms. Lawler would not want to place a petition before this court or any court if they even knew that they had a right in question that was violated, but would still lose. Again, if you go to the record on page 4, Ms. Lawler was noted by this court, by the 13th Circuit at least, that her rights were violated. The court found that Mr. Carter's conduct was unconstitutional, but she still lost. It's because the 13th Circuit found that there was no controlling case from the Supreme Court or the controlling circuit that would allow her to vindicate her rights. And the balance of qualified immunity is supposed to be balanced. But
I mean, so I understand that argument, counsel, but I guess I'm just thinking, qualified immunity has been a pretty hot topic lately. I guess I'm just thinking, like, if we adopt your point of view, wouldn't that open the floodgates for all kinds of public officials to get sued? I mean, and then wouldn't that lead to people not even wanting to ever take public official jobs? We need public officials for, one would argue, I guess somebody who is an anarchist would not argue this, but I would argue that we need public servants and folks to be protected by qualified immunity.
Respectfully, Your Honor, no, it wouldn't cause the floodgates of litigation. This court has always found in Anderson, Creighton, and Harlow, opening that sort of discovery to certain plaintiffs would entail that. However, it's always been in context to police officers. It's because police officers are routinely subject to constitutional violations. However, retaliatory firings under the First Amendment are quite rare. Mr. Carter's conduct was quite rare here. So if we open up...
Because it's quite rare, how does the rarity affect that analysis at all?
Your Honors, because what we're asking, and on the record at page 20, what it states is that for the purposes of a First Amendment claim, what is the standard for clearly established law? If this standard was open and broader, it would not open the floodgates of litigation. Rather, it would open up the opportunity for plaintiffs like Ms. Lawler to vindicate their rights, which is always a good thing for plaintiffs and always a good thing for American citizens. Again, Ms. Lawler was a good employee. She did nothing wrong. And this really goes to my second point, Your Honors, because what is the question that Ms. Lawler is really trying to seek an answer for? Her rights were violated because of her husband's speech. She did nothing wrong. This court in Loving stated that it wanted to protect the dignity of individuals to create a relationship with each other. It wanted to protect marriage. This court in Obergefell said that marriage protects the dignity of couples to create something that's better than themselves. The right to intimate association protects personal choices that are integral to relationships, things like abortion, child rearing, education.
Are you asking us to expand the scope of the right to association? Because I don't feel comfortable with doing that.
Your Honors, we are, and it's a good thing that we should. The court in Adkins and Adler in the Second and Sixth Circuit stated as much. Such conduct that Mr. Carter is doing right now is going to tell people that they have to choose their job or their husband or their spouse. And that is not something that is constitutional. And that's exactly the point here, because the right to intimate association is a hybrid right. The First Amendment protects many things. It doesn't protect obscenity, fighting words, or unprotected speech. But the speech of Mr. Lawler was incredibly protected and is under the Pickering balancing test. And for these reasons, Your Honor, because the right to intimate association is a hybrid right, and that Mr. Carter did have fair notice that his conduct would violate the Constitution of the United States, this court should reverse the 13th Circuit Court of Appeals on this issue. Thank you.
Thank you. Okay, that was great. So that is an example of an oral argument. Let me see if I can get back to the slides. Let's see. Okay, can y'all see it? Can you? Okay, you can. Okay, so yeah, so this is really just the last slide. But if you have any questions, well, first, does anybody have any questions? Let me just wait a few minutes. Unmute yourself or ask them in the chat. I'll just give us like a minute.
Yeah, can I make a plug for Moot Court, Emma?
Yeah.
Okay. So, hey everyone, I feel really fondly about the John Black competition because, believe it or not, I did not consider Moot Court my first year of law school, but my friend Cade, who I'm actually a partner with for a competition, he asked me to join, and I said, all right, let's do it. And I did it, and it was an incredible experience. And I've been on the Moot Court team for some time now. I did the ABA competition my first year, the Billings competition, and then I'm now doing the ABA competition this year. And I'll just echo a lot of the sentiments that Emma is saying. I will tell you, every single OCI interview I've ever been at, the one question they always ask me is about Moot Court and what I've learned in my competitions. It is an incredibly useful skill to be able to do oral arguments and write a brief, and you are going to get a leg up during your interview process, and it will stand out. So that's all I have to say.
Yeah, thank you for saying that. I want to just like add a little bit onto that. So I think that especially if you are, not in the top like 15% or whatever, I think that Moot Court is incredibly important. I am not in the top 15%. And I think that Moot Court has been invaluable to my success in law school. Again, as I kind of said earlier, first of all, it's a great resume booster, great for interviews, as Rahul said. But it also just really, I think it helps you become a better law student. And I certainly think it will help you become a better lawyer. So yeah, let's see. Are there any, I can't see the chat. Are there any questions in the chat?
I have a quick question.
Yes.
Yeah, thanks so much, and agree with your plugs, because I spent one entire OCI interview talking about Moot Court and mediation and the person sharing their experience. So it does come up. One quick question is on Professor Simpson's lecture, has the information gone out about that yet? Because she was going to do it today, but I haven't seen an invitation.
Yes. So unfortunately, because the school and everything is shut down, she told us that I'm so sorry, I should have mentioned this in my email. She said that she did not feel comfortable doing it today because everything was shut down. We even kind of thought about rescheduling this, but we were like, there's no way we can do that. So it will be on Monday from 4 to 6. And I know that some of you guys have classes at that time. Unfortunately, it's still going to have to be that time. That's the only time she can do. But it will be for sure sent out, and she's always available via email. She's extremely responsive. Yeah. Does that answer your question?
Yeah, I think so. So the invitation hasn't been sent out yet, right? For the reschedule on Monday, but it will be.
Yes.
Okay. All right. Thank you.
Yeah, no problem. Are there any other questions?
And her lecture, it will be recorded and it will be sent out and all that stuff, because she gives some really great breakdown that is, I think, really, really useful. Even if, you know, you end up doing something else, I think it's just really, really useful to have her information. Plus, Professor Simpson's the best. So she's just a joy to watch anyway.
Are there any other questions? Okay, so if no other questions, feel free to reach out to me via email. I know a lot of you guys have already done that, so that's great. I'm literally always on my email. I think I'm on my email more than anything, with the exception of Twitter. So yeah, feel free to email me, even text me. I'm actually more responsive via email, so I prefer that. But if you need to text or call me, you can do that too. I'm gonna figure out how to send this out. Let me stop sharing.
Well, what we normally do is on our advocates website, which I put in the chat, there is under competition, the tab, there's something called competition resources. And we put like all of this information. There'll be like a moot court one. That's what we did for the mock trial one, and it was really, really helpful. Where we put like just the documents and those sorts of resources and the PowerPoints and things there. So if you guys go to like the advocates at UHLC, which by the way, registration for this competition is now currently live. It just went live. So if you've got your partner lined up and you guys have got your, you know, ready to go, then that is ready for you. And I see that we actually already have one person signed up. So y'all better get on it.
Yeah, because remember, there's a limit for 32 teams. So you definitely want to, you know, don't wait till the last minute. Register now. Yeah, I think I'm probably gonna send out these slides like immediately, and then figure out how to send out the recording at some point, like soon.
Yes. Well, the recording we'll put on our YouTube page. That's where we typically put things, and then we will send all that out. Our handy dandy website man Joe will be putting that on the website as well. So we'll have all those resources for you. Also in the chat, I put a link to something else that's on the Blakely website, the Blakely YouTube, which is the Blakely Butler moot court final round from back in September. That was the moot court competition that we had that was open to all students. And the final round was streamed onto YouTube. So if you want more examples of what to expect, that's also a recent Zoom example from one of our advocates competitions. So we've got all the resources for y'all. Don't be shy. We've already got now 2 teams signed up. So y'all better hop on it.
All right. Thank you guys so much. I'm going to stop recording. Let's see. Stop.